Get ready. 3 seconds. 2 seconds. Start. These 4 appeals by special leave are directed against a common judgment of the Assam and Nagaland High Court acquitting the respondents of the offences under sections 302/149 of the IPC and will be disposed of by a common judgment. The 4 respondents in these appeals were convicted of the offence under the above sections by the Additional Sessions Judge Gauhati, in whose court they were tried jointly along with Nirendra. The victim of the offence was one Kotwal. Nirendra conviction under section 302 of the IPC was upheld by the High Court, but there being no appeal on his behalf against that order in these appeals, we are not concerned with his conviction. The prosecution story may now be briefly stated. On May 20, 1962, at about 10 or 11 a.m., the deceased and some other Nepali persons were grazing their cattle in Agarkata Government Grazing Reserve, which is described by PW2, the informant, as Koirani Reserve. The 4 respondents, with Nirendra, armed with deadly weapons like bows, arrows and lathis, tried to take the grazing cattle for impounding them on the plea that these cattle had strayed into their thatched field in the reserve. On protest being raised by the graziers, the accused persons assaulted them, and Nirendra, whose case is not before us, younger son of accused, shot an arrow at Maniram and killed him. There were about 16 or 17 kacharis present at the place of occurrence on the side of the accused persons. Angry's respondent in CRA 77 of 1967 is alleged to have hit PW2 on his head with a lathi. It is the prosecution case instigated the accused persons to assault the graziers. The trial court convicted them all under sections 302/149 of the IPC and sentenced them to imprisonment for life. That court observed that though Barga is an old man and has himself not armed, he was nevertheless the leader of the accused and should have known the offence likely to be committed, the unlawful assembly. On 5 appeals having been preferred to the High Court, that court, in a somewhat sketchy common judgment, allowed the appeals of the 4 respondents and dismissed that of Nirendra. The High Court took the view that there was nothing on the record to show that the common object of the assembly was to cause death or to commit murder. It further held the charge framed by the trial court to be defective and observed that a charge under sections 147 or section 149 of the IPC should also have been framed against the accused persons. In this court, on behalf of the state, it was strongly argued that the High Court was wrong in acquitting the respondents. Reliance in support of the challenge to the view taken by the High Court was placed on the language of Section 149 IPC, and reference was also made to the decision of this court in Majazi versus State of UP 1959 SCR 940. It is no doubt true that according to the High Court, the appellants before it had on the day of the occurrence constituted an unlawful assembly armed with deadly weapons. But that court acquitted the four appellants before it within bracket who are respondents in this court on the ground that there was nothing on the record to indicate that the common object of the unlawful assembly was to commit murder of the deceased. In the opinion of the High Court, the Church also disclosed the common object of the unlawful assembly to be only to commit assault. It is on this reasoning that the High Court convicted Niran alone of murder and acquitted the rest. It was argued in this court on behalf of the appellant, the state of Assam, that the High Court did not consider that murder was likely to be committed by some members of the unlawful assembly, and this omission, in view of the findings of the High Court that the accused do not belong to a tribe which normally carries bows and arrows as a necessary part of their personal equipment, has resulted in erroneous acquittal of the respondents. This has caused gross failure of justice, said the learned counsel. It was submitted that the trial court had, after taking this important factor into consideration, convicted the 5 accused persons, and omission on the part of the High Court to keep it in view is an error which is serious enough to justify interference by this court under Article 136. Section 149 of the IPC, which prescribe vicarious or constructive criminal liability for the members of an unlawful assembly, reads within inverted comma, if an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who is a member of the same assembly is guilty of that offense. Stop.